Hi, my name is Griffin Bridgers. It's my pleasure to introduce this presentation on what you should know about Arizona alternate business structures. This is a presentation designed to discuss, at least on the surface, some of the reforms in Arizona that allow for non-attorney ownership of law firms or of organizations which perform legal services. But I want to remind you that this presentation is not intended to substitute for legal or tax advice. This is being provided for informational and educational purposes only. Now, before we dive into what Arizona has done, it's good to create a lay of the land and understand what law existed before and what has actually been changed. So, most states have rules of professional conduct for attorneys, and I say most, I should say all states really have some body of professional conduct rules, which really, in a lot of cases, are modeled off of model rules that have been promulgated and published by the American Bar Association, the ABA. Now, one of the most important rules in this body, especially in the context of this discussion, is ABA Model Rule 5.4, which has almost universally, at least up until this point, been adopted by every state, but is being softened some. The best way I can really sum up ABA Model Rule 5.4 for you is to kind of note as the general theme that attorneys have a duty at all times to maintain their independent judgment, and thus they typically cannot share fees with non-attorneys. They cannot be employed by non-attorneys, other than in a non-supervisory capacity. They can't have their work supervised by non-attorneys is a better way to put that. And they also cannot work for an organization for which any equity owner is a non-attorney, under which they're supervised by a non-attorney for their work as well. Now, with this being said, really the intent here is to make sure that everybody stays in your lane. Now, you can have maybe attorneys working in-house at a corporation or something, but really what they're doing is they're representing the organization itself. They're not representing outside clients. So that's what really helps here. But what this is designed to do is to keep an attorney in an organization from taking on outside clients and then having somebody else, a non-attorney within the organization, share in those fees or somehow supervise the work or be the face of the relationship to deliver legal advice. So there are some shortcomings to this rule. Now, largely it is important for attorneys to maintain their independent judgment, and that has not changed at all. In no way has that duty softened, and that's going to be the overall theme of today's discussion that everybody who considers this needs to keep in mind. You cannot take away that duty. You cannot find a way to push it or try to get around it, because if you do, you're going to get in trouble. Now, with that being said, there are many proponents in areas such as access to justice and tech and financial planning, who have pushed back on ABA Model Rule 5.4, with the thought that law firms lack the ability to innovate or to scale or attract talent due to the inability to attract maybe outside equity investment or maybe management and control by non-attorneys. So in response to this, there's a few states that I'm going to start to highlight that have started to look at workarounds or softening of this general principle. The biggest one, or the one that I think has progressed furthest, is Arizona, because they now have a permanent workaround which eliminates or modifies ABA Model Rule 5.4, only at the state level, not at the federal level. So this only applies in Arizona. And in essence, what this does is it allows non-attorneys to own, manage, and share fees from businesses in Arizona that perform legal services for Arizona-based clients. So in Arizona, what this structure is known as is an alternate business structure, or ABS. Now, the ABS has as a function the performance of legal services for outside clients, but it does allow for ownership and management by non-attorneys, so long as you don't breach an attorney's duty of independent judgment, and so long as there's an attorney in charge of compliance that we're going to look at. Now, I want to note that this is not a free-for-all. This hasn't opened the floodgates at all. There is heavy regulation and compliance at the Arizona state level, and it's similar to, or in some cases, I think, even more stringent than what a lot of attorneys would face. So, because of the steep compliance requirements, this offering may not be as attractive as it seems if you're just a simple business person reader looking at this and thinking, oh yeah, I should check out this alternate business structure. This may be a great way to create a new vertical or revenue stream. Well, pump the brakes there, because this is going to require a lot more than you think it does at first glance. So there's a few themes to consider before you really dive in as you consider whether an ABS in Arizona is right for you. For one, licensure. You have to get licensed as an ABS in Arizona, and this has to be renewed every year. There's a fee that goes along with that we'll talk about in the next slide. And what ties into that, I'm going to skip around a bit here, is that you have to look into the conduct and character, not only of attorneys within the organization, but also any authorized persons who are considered greater than 10% owners, or managers, officers, directors, whoever's in charge or whoever's benefiting. Those persons have to be disclosed in the licensure process, and their disciplinary history will be scrutinized. So while felonies or misdemeanors or bankruptcies or civil actions, they aren't necessarily fatal, but they will be considered, and they do have to be disclosed. And if you don't disclose them, that in and of itself may be the thing that's fatal. One of the biggest mistakes an attorney can make in the application process as an attorney is to not disclose any civil or criminal action or bankruptcy or failure to pay debts or anything like that. All of that comes into play in looking at character and fitness of an attorney. The same thing applies to authorized persons as well as things like substance abuse history. Things like that, mental health, those all could come into play. So you need to, I don't think you have to have clean hands, but it's something you have to think of in terms of who has a role in this new ABS. Now beyond that, you also have insurance, which obviously you have to have your general liability, D&O type of insurance for the non-attorneys within the organization itself and the organization's general business actions, but there's also professional malpractice insurance that you have to have in place to guard the lawyers and professionals who perform legal services. And with that being said, the legal services don't have any softening of duties, and that's going to be a theme we look at with the attorneys, because independence of judgment is required, and with that, attorneys have to supervise the legal work, and the buck stops with them. So if you're an attorney considering joining an ABS, that doesn't go away. You're still in charge. So if you're getting pressure from management to do something that's going to breach that duty, you have a duty to disclose or get the heck out of there and not be involved with that type of setup. Now, another thing to think of along those lines is the delivery of advice. Only attorneys can deliver legal services or advice. And those traditional duties remain, as I mentioned, and they apply to all persons involved in the ABS. So if you're not an attorney, you can't just claim ignorance. You still have to know about these things and make sure you don't breach any of the traditional duties that an attorney would owe to clients, because the ABS itself, as an organization, is also going to owe those duties to clients. And then finally, compliance. You have to have at all times an Arizona licensed compliance attorney, and you can't just retain an outside firm. You have to find somebody who is an internal compliance attorney, either as an owner or an employee, and that individual has to have no disciplinary history for the 10 preceding years. Now, with that being said, the upfront and ongoing licensure fees can be pretty steep depending on your scale and budget and everything like that. Here's a quick list, and you'll see traditional law firms I start off with. If you're looking at a traditional law firm with outside equity ownership, you're going to have to go get licensed, paying $6,000 to Arizona upfront, and then an annual renewal of $3,000. And it goes on this table for organizations that don't have as their primary function the performance of legal services, so international corporations, non-law firms with greater than 99 employees, non-law firms with fewer than 100 employees, and then nonprofits as well, whether or not they're incorporated within Arizona or outside of it. So you get a sense of the fees here, and I want to mention too that what goes along with this that I haven't listed on the slide is that the initial fee can increase because there's an investigation phase that goes into this. So if the investigation goes beyond a certain point, I think it says 80 hours in the upfront licensure process dedicated by the committee who has to examine the license and get the additional information, then that can tack on additional fees. I think there's a $1,500 overage plus maybe $100 per hour for each hour beyond that. So depending on the scope of what you're doing and how little or how much you disclose, you could easily run well north of that initial fee when you're pursuing an ABS and going through the licensure process. Now, beyond that, I'm not going to dive into the rules as much. What I really want to do is, by anecdote or example, show some areas where the ABS could have issues and where I anticipate, based on my own knowledge of capitalism and human nature and bad acts, that I could see people running to issues here based on a mismatch of what they hope economically to get out of the ABS as opposed to what are the actual duties that an ABS and its attorneys owe to clients. So, for one, you have to consider conflicts of interest. So you can't have an economic model that creates those conflicts of interest. You're going to run into issues. So, for example, let's assume that the ABS is a financial planning firm, and what it hopes is that the attorneys bring in clients, and then the ABS can then cross-sell financial products or financial management to the legal clients. Now, you just don't have carte blanche to do this. That could create a conflict of interest. And even if you don't think on paper it does, the way that the model rules are written is that any sort of sharing of business between an attorney and a non-attorney in and of itself kind of creates a conflict of interest, because the possibility that the attorney could be receiving compensation from elsewhere automatically creates that presumption that there's a conflict with the client to begin with out of the gate. And there's several layers to this that you have to consider, and we're not going to dive into today. But the least of this is that you have to at least disclose the conflict from the outset to avoid getting in trouble. And the greatest of these is that you have to really consider whether the conflict is one that can be or should be waived by the client. Now, just because it can be waived doesn't mean it should, and it doesn't mean you have an easy path to get to that waiver or the ability to waive conflicts on a blanket basis. So, for example, if you're thinking that maybe you can have a terms of service or a simple upfront document that applies to every client where you hide in fine print that the legal services client consents to and waives all conflicts of interest, well, that probably will not be sufficient to satisfy that duty by the ABS. This has to be done on a client-by-client basis, and you can't just do it as a blanket approach. So waiver by conduct or assent by the client probably will not fly. Now, beyond this, what shoehorns into that conflict is also confidentiality. Law firms typically can't disclose their clients to outside persons or the details of their clients' legal matters. And this same principle will create a duty for the ABS to maintain this same confidentiality. And that applies on the outside, but it's also going to apply inside as well. Internal control will be an issue because not all employees of the ABS have a need to know, and your economic model cannot be built on what is, in essence, a breach of confidentiality. So, for example, if you have an ABS which has as a business purpose, let's say lead generation, or maybe selling marketing lists to outside providers, you just can't do that. That's a breach of confidentiality. Even if all you're doing is disclosing the existence of the client, well, guess what? They're going to know where their name came from. And then beyond that, even if the services are offered internally, you probably cannot do that because there might be a duty to firewall internal employees without a need to know from the matters and the legal services being provided to internal clients by the ABS. And even if you could, without breaching confidentiality, once again, conflicts of interest come into play there as well. And confidentiality also bleeds over into privilege. This is another area where I can see a lot going on, and they're not the same. Privilege really relates to, whether the things communicated by the client to the attorney remain secret and can't be disclosed in a legal proceeding or a court of law, but it still shoehorns into this and could cause problems depending on internal information systems of the ABS. So for example, let's assume we have an employee of the ABS who's not involved in the legal services side, but they're approached by a party who might be suing a legal services client of the ABS. Maybe that outside party is a bad actor and acting in bad faith, and maybe they ask the employee, hey, do you have access to records of the legal services side of things? And the employee doesn't know any better. They say, yeah, sure, our internal computers have that. So then, just knowing that, the outside party could then maybe subpoena the ABS for that information because they know it's no longer privileged. If somebody inside can access it, is it really secret at that point? Even worse, you could have a situation where maybe you open up your employees to the risk that an outside party pays them to turn over that information. Well, in either case, that is going to put egg on your face at best, and it's going to result in huge legal liability for the ABS at worst. So internal information systems and firewalling will be paramount. And then beyond that, business protection comes into play too, because traditionally with a non-legal business, if you have an employee who leaves, you could use maybe a non-compete or non-solicitation structure and maybe even a non-disclosure type of agreement or confidentiality agreement to protect the business or its management for better or for worse. But with an attorney, you probably do not have this. And I'll tell you why in a second. But for example, let's assume we have an attorney of the ABS. They get fed up by overbearing management who's trying to supervise them and impede on their independence of legal judgment. And the attorney decides, hey, I'm going to leave. I don't want to deal with this anymore. And then the management, as the attorney is leaving, says, okay, that's great, but we've imposed this non-compete and we require you to sign this non-solicitation and non-disclosure agreement as a condition to, collecting final payment or getting a severance or whatever the case might be. Well, guess what? You can't do any of that. The rules of professional conduct for attorneys will apply to an ABS as well, and they do not allow this because, for example, every client for whom that attorney or the ABS has been responsible for legal services must be informed of the attorney's departure while also being given three choices. They can either stay with the ABS, go with a departing attorney, or retain a new attorney or ABS for their particular legal matter. So that duty overrides any ability to have a non-compete agreement in place. Another issue would be maybe if the conduct of the management had breached the duties of the ABS or the attorney regulations, or could damage clients potentially, and the attorney wanted to leave because of that, then you can't put a non-disclosure agreement in place because the attorney and the ABS both have a duty to disclose that potentially bad action to the Arizona Supreme Court's Committee on ABS licensure and conduct. So that can't be kept secret, and you have a duty to disclose it. So you have to be careful in your selection of management because it's very easy to run into a situation where if you have a bad manager, you've got to get rid of them quick, and you've got to disclose that, because if it's found after the fact that you didn't, your license is getting yanked in the best case, and it could be very difficult to get it back, and you may have even worse actions for unauthorized practice law and other things that come down the pike. But either way, a lot of duties to think of, and by no means is this intended to be all-inclusive. This is really kind of the surface issues of what I see coming into play with an ABS. Now, I'm a tax and estate planning attorney, so this hits close to home, and what I want to provide an example of here is if you have estate or tax planning within an RIA, which is a pretty frequent type of business structure deployed nowadays, and it's one that has changed under the ABS rules. So the traditional approach has been maybe you have an RIA firm and then a law firm, and the two are separate and independent. They may share economic benefits in terms of clients and office space and everything like that, and overhead, but in the grand scheme of things, fees stay on either side of a firewall, where on one side you have the RIA owned by individual owners who are typically FINRA licensed or approved. Then the law firm has attorney owners who are typically Arizona licensed, and ownership fees and information typically don't cross over that firewall. They're shielded from both sides. This is really just more of an exclusive referral type of relationship without a direct economic benefit for those actual referrals. But the ABS approach merges the two, and it might have both the individual FINRA license owners and the attorney owners acting as co-owners of an RIA firm, which is also then licensed as an ABS within Arizona. Now, importantly, you have to have the Arizona compliance attorney on payroll once you do this, and the attorney who's doing estate and tax planning may not be well suited to that type of role. You may need somebody separate, and that firewall doesn't go away. It's important to still have a firewall at least for client information. That goes back to our need to know type of discussion. That may only be accessible by legal staff for client information. So you still have to have the attorneys dealing with the matter and the compliance attorneys saying, hey, if you're an individual owner, do you really have a need to know? Or if you're staff, do you really have a need to know? And beyond that too, you have to look at, all I've addressed here are the ABS types of disclosures. FINRA has its own set of compliance and disclosures, one of which is on your annual form, you have to disclose whether you co-own or use a law firm, and that's its own conflict of interest potentially, and that has to be disclosed through FINRA. So either way, just some things to keep in mind on the surface. And if this is something you're considering, what I typically tell most RIAs is if you want to bring an attorney in-house in one of these structures, in 90% of the cases at least, it's not a good idea and is premature. So don't do it. There are ways to bridge that gap, and I'm happy to be a sounding board for those and discuss solutions for you. But going all the way to bringing an attorney in-house or going the ABS route, it may not work for more reasons than just the compliance, more so for just the volume of business and whether it makes economic sense and truly serves the client at the end of the day. So that's all I have to discuss today on ABSs. I plan to cover, some of the rules as apply in Utah as well as Florida, which also has its new set of rules coming out soon. But either way, in the meantime, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com with the caveat that I cannot give legal or tax advice in response to your questions. But thank you for listening to this presentation, and I look forward to seeing you in my future content.